Welcome to my presentation. I am Ravi Krishnatma Chaube and I am going to be presenting about my paper titled Custodial Violence, a festering wound on the body of the rule of law. In the Indian context, custodial violence takes a central issue while we talk about the various miscarriages in the criminal administrative system. Custodial violence is an example of police brutality in which the victim or the person who is in due effective legal custody of the police is subjected to physical and or mental torture but dispensed by the hands of the police officials who are themselves under the legal charge of the accused. Now, this custodial act of explicitly exposing one individual to inhumane actions of violence, both physical and mental, is in complete disregard to the constitutional integrity of the nation and of the state, but at the same time effacing the idea of the rule of law. The rule of law can be very easily understood as the central idea which maintains that all the actions or all the state decisions that are taken by part on any central government or authoritative body in a society should be reasonable and should be justified and legitimate under the eyes of the law. It further states that everybody is equal under the law, and at the third instance, it provides for the separate independent judicial working. And we see that in India, custodial violence is failed by three problems that occurs in the legislative as well as the political scenario of Indian administration, which failed to effectively tackle with issues of custodial violence and thereby destructing the people's trust in the criminal administrative system. One of the first problems in the Indian context is the legislative incompetence and the dereliction that is done with regards to the topic of custodial violence. That despite there being excessive statutory and procedural safeguards against the powers of the police, they are not effectively implemented, and the legislation, by ignoring the anti torture bill in 2020 and by ignoring the 2017 Prevention of Torture Act that was purported by the 273rd Law Commission report, have shown that they are legislatively failing the idea of rule of law by being lackadaisical in this approach to the issue of custodial violence, and has led to the degradation of the ideal of the rule of law by allowing state officers to act with impunity against a very poor population accounting for almost 68% of the world of the country's population living under $2, who are not at all aware about their political or civil rights. In the second case, there has been a lot of judicial discourse in the courts via the courts, but at the same time, there has been not proper implementation of such judicial decisions. We see that in Mahmood Nair Azam versus State of Chhattisgarh, where the Supreme Court decided that torture or police crimes are itself violative of Articles 2021. When Prakash Singh versus Union of India, the Supreme Court laid down a police complaints authority model that is to be followed by every state. We see that there is a second failure of law happening where there is no proper enforcement of judicial decision, and the failure of the rule of law occurs by the implicit denial by the state authorities to follow judicial decisions and uphold the supremacy of the court as the final decider in what the matter of custodial violence should mean. The third failure of law occurs in the ineffective realization of certain human rights and liberties as being sacrosanct, which cannot be overridden by the mask of statutory authority, the rule of law. I conclude in my final parts that rule of law in a country such as India is of extreme importance as it holds the idea and the primacy of a certain constitutional network, that there is belief in our system that human rights are to be valued and are to be taken at a certain level which cannot be abrogated by any authority or official body. I thank you for listening into my presentation. This is Raghu Krishna Atmachabe.